the officers' update, then immediately we went to public speakers, and then we took questions to the officers. And that seemed to work quite well at main planning. So we're going to try that tonight and see how we go, just an attempt to try and slim down the sort of various different parts of the meeting where we're sort of going backwards and forwards a bit, but we'll see how we do. We can move then on to the main agenda. If I could ask, if I can't see any, firstly, any apologies. I think we've got all honourable members, haven't we? Yes. So if I could ask if there are any declarations of interest. Councillor Crawshaw.
Thanks, Chair. I just wanted to update committee members. During the second half of last year, I had a lot of exchanges by phone and email with the applicant for agenda item 4A, who'd contacted me as her ward councillor following the determination of her previous applications. And following that contact, I engaged in dialogue with both planning officer, head of planning, development manager. Those conversations were all limited to discussions around process, the process that had been followed in determining the previous applications. But I did also give some explanations to the applicant about her procedural options that were available to her at the time. At no point during those conversations or dialogue did I offer an opinion on the merits of the previous applications, and I've only had limited contact following the submission of this new application. The dialogue that I've had has principally been focused around the applicant's request for this new application to be determined by committee rather than under the scheme of delegation. I've discussed my prior involvement with the legal officer, and I'm satisfied that I'm not predetermined in any way. However, given that I've had more contact than I would ordinarily have with an applicant in advance of a committee meeting, and given that we've got a full gamut of committee members present here today, I feel that on balance it will be sensible for me to withdraw from that agenda item, such that there can be just no possible suggestion that my involvement to date could have been any sort of influence in the determination that's made. So I'll leave the meeting at that point and return again once that item has been concluded.
Okay, thank you. Councillor Crackle.
Thank you, Chair. Yes, just with regard to agenda item 4B, I just wanted to say, for the sake of transparency, that as one of the Guildhall ward councillors, along with the other Guildhall ward councillors, I have attended the Minster Neighbourhood Forum. I don't believe that's a prejudicial interest, but just for transparency, I wanted to say that. Thank you.
Thank you. Move on then to the minutes. So we've got two sets of minutes from the 30th of November and the 8th of December. If there are any comments, if you could stick your hand up. Otherwise, if we're happy to sign them as they are, if we could just raise a hand. I think everybody's happy there. So if we can, yeah, I'll sign those next time. I've got a physical copy. There's no speakers under the general public participation remit of the committee, so we can move straight on to the plans list. We'll just make a slight rearrangement here and move item 4B ahead of item 4A, and that's because we've had a request to defer item 4B to a later date. I'm happy to move that straight away if anybody's willing to second it. Councillor Galvin, I saw first. I can't see any need to sort of debate that issue. Obviously, it's a request from the applicant to defer the item. But Jane, if you could just conduct a named vote on that as we would for any other vote.
Okay, so I'm going to take in the order I have you on my screen. So Councillor Crackhill.
4.
Councillor Crawshaw.
4.
Councillor Fisher.
4.
Councillor Perrott.
4.
Councillor Daubney.
4.
Councillor Galvin.
4.
Councillor Orrell.
4.
Councillor Wardby.
4.
Councillor Melly.
Abstain.
Councillor Webb.
4.
Councillor Hollier,
4. Is that everyone?
Yeah, that's deferred.
Okay, so I think that's deferred with however many others there are. 12, 4 and 1 abstention.
correct.
Thank you. And I've just popped in the chat as well the alphabetical list, because I think probably people will move around as they're speaking. So hopefully that'll be helpful next time. Can we move on then to item 4A? Sporting Mount Parade, and Gareth, if you could begin.
Thank you, Chair. We have the case officer for this application, Sandra Duffel, who's in the meeting. I think she's joined by phone for this one. So this is an application, a listed building consent application for 14 Mount Parade, internal and external alterations, including basement level extension to the rear, 1 roof light to rear, light well to the front with replacement front window at basement level, part lowering of the basement floor, and insertion of stud wall and new staircase to attic at first floor. I will share my screen and share the presentation. I'm sorry, host, you need to enable screen for me to screen share. That's okay.
That should work now, Gareth.
Great stuff. And Sandra, if you could just come in if necessary, if you feel there's anything that needs pointing out in the presentation.
No problem, Gareth. Thank you.
Okay, so 14 Mount Parade is a Grade 2 listed building in the conservation area. This is the as proposed site plan. So it shows a rear extension in the basement yard. The rear is at a lower level than appears 2-story to the front, 3-story to the rear. And this light well proposal in the front garden to give additional light to the basement front window, the roof light that I mentioned. This shows the existing floor plan. So there's a front basement room, rear basement room. It's an extension to the rear, which has a bathroom and a lobby. The stair runs up the shared wall to the left-hand side. At ground floor, the original 2 rooms have been combined into one, retaining these nib walls to show where that separation wall used to be. At first floor level, a room to the front and a room to the rear. The staircase, a very small landing, and then the loft area is doesn't have a stair to it. It's accessed through a loft hatch at the moment. The proposed floor plans. So this shows the alterations proposed to the basement, which would be excavating a larger light well and introducing a larger front window, which would also be a fire escape window, and putting an ensuite bathroom. The new extension to the rear is an extension to the kitchen, so the dining family space. At first floor, subdivision of the existing rear room, which is currently a bedroom, and that would be a new bathroom with an extended landing and hallway to allow a staircase to be taken up to the loft room, which would be a third bedroom. An existing section through, and this illustrates the current situation in the front basement room. So because of its original use as a store, it has lower floor to ceiling height and a raised floor through from the kitchen area. Proposed section, so that shows the floor level excavated, window introduced, light well excavated further. There still would be a step from the kitchen area into that bedroom. It's a section through the new extension to the rear. You see the staircase going up into the loft room. Existing elevations, so there you can see the existing basement, front basement window, existing extensions to the rear, and in elevation, side elevation. Proposed elevations, so you have this larger front window, and then the rear extension, rear roof light, side elevation of the rear extension, so taken from that point looking into it inwards. Members will also have noted that I circulated some photographs with the subcommittee update. This is because they are photographs of the which show the internal layout of the house, inappropriate to have on a public Zoom call. So if members have those to hand, I'll just run through them. Photograph 1 shows the ground floor front elevation of the house. Photograph 2 is the front basement light well. Photograph 3 and 4 are photographs of the rear elevation. Photograph 5 is a photograph that's taken from the kitchen into that front basement room, so you can see those two steps, and the window is illustrated in the lower photograph 6. Photograph 7 shows the staircase looking up to that that first floor landing, and then there are 2 photographs taken in that first floor rear room. That concludes the presentation. If members want to see any of the drawings again, I can go back.
That's great. I'll just ask if members have got any very sort of quick questions on the drawings whilst they're up, and because we will then move straight to speakers and then come back to sort of substantial officers' questions. So if there's anything very specifically you'd like to see again, you can raise a virtual hand. If not, I'm going to move on to speakers. I can't see any hands. So
okay, I'll stop sharing.
Linda Grainer, if you're available. And Ms. Granger's the applicant, obviously speaking in support. If you can hear me.
Hello.
Hello, we can hear you.
Hello, I'm Diane Baines, the agent. I'm down to speak first.
Not on my list, but I won't argue too much.
Can you see us?
I can't see you, but
we were told we'd be on video.
You're within the sort of Zoom call, but you're not sort of visible on camera. But it's not necessary to sort of.
No, we really had hoped that we would be able to engage with the committee
Yeah, Chair, it's Richard Jackson. If you do wish to appear by video, there's the start video button in the bottom left-hand corner.
Is that for us?
Yes, that was, sorry, it's Richard Jackson. The
Oh,
technical
it's
support.
the chair, is it?
Okay, I'm on an iPad, and when I press start video at the top, it says you cannot start your video because the host has disabled it.
Hello?
Yeah, apologies, I'm just looking at the settings here. I can't see anything that has allowed me to turn your video on at my end. My apologies.
Okay, well, I think if we can move
Okay.
on to your 3 minutes.
Oh, hang on.
Yes.
Can you see us now?
Yes, we can see you now. So
Excellent. Oh, thank you so much for persevering. It's much appreciated. So I'll start. I'm Diane Baines, the agent. The report describes the terrace and number 14 as a delightful row, which makes a positive contribution to the conservation area. The applicant's window and light well proposals mirror those already at 12, 13 and 14. Yet the report says the alterations would detract from the listed building. How can the alterations create both a delightful and a detracting effect? There is only a glimpse of the window and light well in your photo number 1, if members refer to that. The report claims the basement works would remove evidence, but the applicant has provided drawings, officers have taken over 100 photos, and a video record could be made. This substantial evidence can remain in the public realm. There's no public benefit in physically retaining a concrete floor and modern window. The first floor works are essential to form a fire-safe route to the attic. These works do not remove fabric and are reversible. Historic England's Advice Note 2 says preference should be given to reversible works so that changes can be undone. Whether they will be undone is not a legitimate criteria for assessment. Similar works to these have been widely approved in the terrace precisely because the original plan form remains legible and doesn't harm integrity. The report fails to explain why the approved 2004 works are no longer acceptable. The underpinning legislation then and now is the 1990 Act. The 2004 report says the alterations would protect the architectural character of the dwelling, and the report said the scheme would maintain the integrity of the listed building and provide a more useful, habitable building for contemporary living. Approval was recommended. Now, since 2004, PPG 15 has been replaced by the MPPF, which is actually more lenient in this case because it allows optimum viable use and public benefits to be offset against any harm. The optimum viable use for these properties is evident in the neighbouring homes, which have 100% use of their basements. Number 14 is clearly in suboptimal use, contrary to the objectives of the MPPF. The MPPF actually supports these alterations as they put the building to its optimum use. Turning to public benefits, of great concern is the report's striking omission of our submitted statement of public benefits and its repeated failure to weigh these against the perceived harms. Wrongly, it repeats there are no public benefits. There's no weighing of the public benefits of replacing the extension. Neither are you told of the public safety benefits of providing essential means of escape from both the attic and the basement room. Improving fire safety standards in the house is a public benefit and will protect the lives of public workers. Nor is the benefit of adding to the city's stock of family housing considered. Contrary to the report's conclusion, there are clear and identifiable public benefits. These do outweigh any harm, meaning the proposal does comply with the 1990 Act and the MPPF. As such, it should be approved. Thank you.
Thank you. And if you could just hang on the line a minute, I'll just ask if the committee have got any questions and Councillor Webb, would like to go first.
Thank you, Chair. You've just sort of suggested some public benefits, but could you outline how internal alterations to a private dwelling lead to public benefits? Could you just give us a bit more detail about that? Because I think that's going to be quite important to this decision.
Absolutely, thank you for the opportunity. Yes, first of all, the report says that the removal of the rear flat roof extension, I think the report calls it a detractor, as in a detracting effect. Well, that will be demolished and it will be replaced with a much more sympathetic extension. So that's a public benefit because we're removing something ugly from this listed building and replacing it with something far more sympathetic. With regard to the internal works, the property at the moment is quite small. It has 5 rooms, and the applicant will come on and explain how that's used. At the moment, where I'm sat in the basement, you can see I'm sat in the kitchen, and that's the room behind me. That's the window that we want to change. That room at the moment is barely usable because the head height is low. I could walk in there and I'm 5'9" and I'd bang my head. I can't escape from the window. It's a fixed window. It's got the fire safety officer requires there to be a means of escape in that room if it's used as a bedroom. Obviously, the window is fixed. It's too small to crawl out of. It's too high to climb out of, and it's too small and cramped light well for a fire officer to get in, a fire responder to get in. Now, it's in the public interest, it's a public benefit that our housing stock is safe to live in for the people who live in it. You might see that as a private benefit, that the people who live here, the family that lives here, has an adequate means of fire escape in case of an accident or an emergency. But that actually is a public benefit because there are public workers who will respond to that emergency. They need to be able to access the property and find a means of escape. That's why that window is necessary. It's of public benefit and public safety to public workers. It will also have a knock-on effect to the NHS, because obviously if there is a terrible accident here, if you do refuse consent, and there is a accident, then obviously
I think I've got your point.
Could I just add
you for
the
that
final,
one.
there were 3 benefits, and the third benefit is that this house is underutilised at the moment. It's got 5 rooms, but it can only safely use 4. It's not a generously sized house. It can only safely use 4. In terms of sustainability, it's essential that we use our homes really effectively and that this is a family home and it's used fully to its optimum use. So that would be a public benefit because it adds to the housing stock of family housing. Thank you.
I can't see any further questions at that point. So I think if we're able to move on to Miss Baines, who I believe is there with you.
Yeah.
Okay. Let me get through.
Sorry, yes, you'll know you've got 3 minutes to address the committee, and I'll give you a warning.
Okay, thank you. Thank you, Chair. I'm Linda Grenier, and I live at number 14 with my 6-year-old and 17-year-old sons. Our home has 5 rooms and a bathroom, 2 bedrooms at the first floor, a sitting room at ground floor, and a basement level dining kitchen and bedroom. The bedroom is accessed off the kitchen. It has a sloping floor, a low ceiling, and a small fixed window. I tell you, it is depressing and dangerous fire trap. Visits by building control and fire safety officers conclude that as the basement room's only exit is through the kitchen, it must have a separate means of escape. I need to make my home safe for my family to live in. Upstairs, I need to add a stud wall and a self-supporting staircase to access the loft. And downstairs, I seek to replace the rear extension, level the basement floor, and form an escape window and light well. The report recommends refusal of the safety works, which condemns 20% of my home as unusable and unsafe. And it's unsustainable to have 1/5 of my home unusable when we're in need of another bedroom. Under the council's own housing criteria, my son should have separate rooms. The other 3 houses in the row have all been allowed to make identical alterations, and they have full use of their basement room. They have optimum use. They're allowed to live in 100% of their homes. So by allowing me to practically and safely use the basement room, you would be allowing the optimum 100% use of our home. Also, in 2004, this house was granted permission for these same works, but the owner didn't carry them out. Apart from my extension being smaller, actually, these works are exactly the same as those approved. The report ignores the public benefits of the works, which are: 1, removal of the ugly roof, rear extension. Public benefit number 2, public safety. As Diane has said, the window and light well create an essential emergency exit and allow emergency responders to safely access this part of the house. It benefits public services and the NHS that York residents are allowed to live in homes that are safe and don't put others at risk. Public benefit number 3, it creates a family home which is put to a sustainable optimum 100% use. My neighbours and the Micklegate Planning Panel fully support my application. I'm asking you to approve works which you've previously found acceptable, all of my neighbours have already done, and which deliver 3 clear public benefits. So my son can sleep in a much needed separate bedroom, which is safe. Please allow us to live in this home safely.
Thank you.
Thank you.
Let's ask if there are any questions to Councillor Webb again.
Yeah, apologies, guys. I promise I'm not picking on you, but my question is actually sort of related to your neighbour's property. So you might not be able to answer this, but I thought I'd ask why you were here. Are you aware of, because I assume that they've had their works done in the past, obviously, since it was built. Are you aware of it? Was it recent? Have their properties been altered for quite a long time?
Diane can answer this question.
Hello there. Maybe I'll be able to answer that because I did the history check for Linda. Yes, all the works were approved around the same time, as sort of the late 90s, the early 2000s. But the really important thing I would like members to recognise is that the relevant policy has not changed. The Act that was relevant then.
That's fine. Thank you.
So,
that's great. Thank you.
The playing field's the same level playing field.
Thank you. I can't see any further questions at that point. So thank you for your time this evening. Obviously, your comments will be taken into account as we sort of consider this item from this point on. I think you will now be taken out of the Zoom meeting, but you will be able to continue watching on the Council's YouTube channel. So if you wonder why you suddenly disappear out of here, that will be why. But thank you very much for your time. If we could move on then to questions to Gareth. And again, if people could raise their virtual hand. I could see Councillor Wardby.
Thank you, Chair. It was mentioned by the speakers that there's been work on neighbours' houses. So my first question is, are they listed buildings as well, I presume? And second of all, they also mentioned that there was approved application in the past of the same works, but the extension was a bit smaller. Is this true, please?
Thank you, Councillor Woodby. We do refer to the 2004 permission that is referred to in the planning history and in 5.18. So there was a list of building consent granted back then for very similar internal works and slightly different external works. In terms of the neighbours, we have a list of building consent for number 12 Mount Parade from 2001, and then another one from 2006. So that 2006 one was for a single-storey pitch roof rear conservatory. We don't have any property history for number 13. 15 Mount Parade was an extension permitted, an excavation to the front basement area in 1998, and other internal and external alterations. Yeah, those Sandra, could you help me out here? Those properties, 12, 13 application property and number 15 are the buildings which are in the same design. There's a short terrace within the terrace.
That's right. Numbers 1 to 18 are all grade 2 listed on the one side of Mount Parade, but this particular group stand together at 12, 13, 14, 15. So they are quite comparable. And as Gareth says, there have been 2 permissions, one in 98 for number 15 and another in 2001 for number 12. I couldn't find property history for number 13.
Thank you. And the 2004 application on this site, presumably that's timed out, has it? That's why it's not.
Yes, it would have. 2001, it was probably still a 5-year permission at that point. It might have been a 3-year. But yes, it's not capable of implementation now.
Okay. Councillor Wardby, sorry, you got supplementary?
Yeah, no, so if there was an application in 2004, has there been any change to planning law? Because it was approved then. If it's a similar of planning application, why has it been refused this time? It's been proposed to be refused, sorry.
Yeah, the legislation in terms of what it says in the 1990 Act, which is was obviously in place then. What's changing? The principal thing that's changed is the introduction of the National Planning Policy Framework, and this way of assessing applications for alterations to heritage assets, and the need to assess the significance, give great weight to avoiding harm to listed buildings, or rather give great weight to the asset's conservation, and then balance that level of harm against public benefits. So that way of assessing the impact of alterations through listed building consents wasn't in place prior to 2012 and the introduction of the NPPF. Whilst the planning policy statement that was in existence then, in terms of listed buildings and heritage assets, had a great deal of information about what made particular types of buildings special and what was important. It didn't have that method of determination that the NPPF has now.
Okay, Councillor Crackhill.
Thank you, Chair. Yes, I've got 2, maybe sort of 2.5 questions. The first one is about the front elevation, which I don't know if we need to get that up or not, but it's page 33 and page 34 of our papers, and it shows the front elevation as it is now of the terrace of 4 houses, and the front elevation as it would look after the proposal if it was implemented. And what I'm struggling to understand at all is why your sort of average person in the street walking past would not see the result after the proposal as preferential to what it looks like now, where the current house looks completely out of keeping with the others. So just in terms of conservation or whatever of appearance of the conservation area, I just wondered if you could explain that a bit more.
Yeah, for a listed building consent application, we're looking at the impact of the building on its own, really. So what we're looking at as set out in at the start of paragraph, as part of section 5, is the impact on the special architectural and historic interest of the building. So whilst we can take account it to some degree in terms of its impact on the conservation area, my view is that the correct assessment is the alterations in terms of the architectural interest of the building itself.
Can I have a supplementary on that, Chair?
Yes.
It also seems like, in a way, you're saying it's a bit tough luck on the occupants of number 14 that they're the last people to bring forward the application, because that means they're the only house that's left with this historical item of historical interest. Is that what
Well,
you're
we
saying?
have to look at the application as it's submitted to us, and these decisions are snapshots in time. So we look at it in terms of today's policy and how the building is set out and its appearance and historic interest at the point of determination.
Okay. So my second question is about the question of public benefits as put forward by the applicants. But I wanted to ask, first of all, mainly about their third point, which is making this property into far more viable family housing. And the suggestion in the paper that is only a private benefit. Now, I'm sure I remember from previous applications and previous occasions, do we not regard the provision of family housing as a public benefit? Could you comment on that, please?
Yeah, I think the thing is it's already considered to be in its optimum viable use at the moment, because it is in occupation as a dwelling house in its original as built form. And I suppose the argument is that its continued viable use as a residential dwelling isn't dependent on those proposed works. The building's capable of ongoing residential use in its current condition. It's the occupation by the owner, which is who wishes to use the building in a different way. But I'm not sure that can be used as a public benefit. Public benefits are supposed to be, by their nature, of a scale beneficial to the public at large, not just a private benefit. We've had the occasional appeal decision which has set out and backed up that view.
But we do have clear policy on the desirability of providing more family housing, don't we?
Yes, in terms of planning decisions. I can only think at the risk of repeating I'm not going to repeat what I just said, but it's already considered to be in optimum viable use at the moment. It is a house. It's a small house that the alterations that are proposed would allow to be used in a fuller form. They allow use of the basement. They allow use of the loft room, but that then creates this tension with the policy requirements of the NPPF in terms of allowing those alterations.
Okay, move on then to Councillor Galvin.
Yes, Chair. I mean, a lot of what Gareth has said has partly answered what I was going to ask, and this is the question of fire hazard and associated problems. I suspect that what Gareth is going to say, and you'll no doubt confirm it, Gareth, Gareth, that is not in essence a full planning matter. It might be a common sense matter, but as we all know, common sense and planning don't always go together. So can we not put any weight on the fire recommendations at all? Am I right in assuming that? And secondly, damage, of course, is very much, or would you agree that damage or the description of damage or the level of damage is somewhat subjective?
The issue of the fire safety, it's a difficult one, because I assume as the house was occupied previously, it wasn't an issue, because the room wasn't used as a bedroom. So again, it's that issue of a householder wishing to make those changes to occupy it as a bedroom in a safe manner, which has resulted in the application in front of members. I mean, ultimately this is a recommendation, and this is the assessment. You've seen the assessment of the conservation officer in 3.1, 3.6, and then the assessment of the case officer, and then the balance of harm versus the benefit to residential amenity, which is set out in 517, 518. And those assessments are that there is harm, less than substantial harm, and there aren't any public benefits, because what's been put forward are essentially private benefits in our officers' view. Members can come to their own view on the level of harm and whether that harm is outweighed by public benefits that you perceive. But I would say that you have to determine this application in line with the NPPF and the Act in making that determination. Councillor Galvin, you asked a second question that I've now managed to forget.
So have I, so don't worry about it, Gareth.
I know I was going to bring in Sandra about, it was about the essential subjectivity of
Yes, damage.
of damage, harm to the listed building. Sandra, I wonder if you could come in and just explain the.
Can I just add to that, Gareth? I'm looking at photograph number 1. So one might argue, and would you agree, that the property to the right, which I think is it number 12 or number 14, obviously has been damaged because it has the kind of windowing that the current applicant is putting in. And that's really the point I'm getting at. Damage, would you agree? No, that's probably unfair. Do you accept that damage, level of damage, is subjective? And it's the interpretation in the eye of the beholder. It's a bit like beauty. It's in the interpretation of the eye of the beholder.
I can accept that in the past we have made decisions, not necessarily for all of the alterations shown, which the decision makers at that time felt didn't harm the building, the architectural special historic importance of the building to a level that justified the refusal of a listed building consent, but under a different policy assessment regime.
Okay, thank you.
Thank you, Councillor Webb.
Thank you. Sort of following on from Councillor Galvin's question about fire safety, really. I suppose could you just give us some advice around policy, really? If you know, if as members we've been made aware by the public speakers and discussions this evening that you know, a supposed public benefit would be if this room becomes habitable, then we'd be putting a proper window in it that someone could get in and out of. If I'm right, in the photos, this room is already being used as a bedroom, I think. And I suppose my question is, you know, where do we stand around making a decision if we know that one decision would make something more safe and one decision would leave it where it is? You know, how do we weigh that up? And yes, I heard that, Councillor Garrett. That's my question, really. Is it a planning consideration? Is it not? And if not, why not?
I'm not sure I can answer that question. It's the use of the room as a bedroom, which then results in issues of fire safety and fire escape, are a decision of the householder. And I think I would find it difficult to justify that decision when the result of that decision to use that room as a bedroom then requires intervention to statutory listed building, which is assessed as by our conservation staff as being harmful to the listed building. So having said I couldn't answer it, I think that's my answer. But it's a tough question to ask, and it's a tough question to answer, and it's a tough issue to make a planning decision on.
Okay, thank you. I can't see any further questions at that point, so if we're happy to move into debate, if any would like to make a start. Councillor Galvin.
Chairman, I'm more than happy to make a start, and I do take on board. I wasn't trying to catch Gareth out, and I do take on board an awful lot of what's been said, and I take the point. It really, the fire issue, whilst it's something that we can feel very strongly about and can be quite emotional, really was to put on one side. My argument is pretty simple, that I am not convinced that damage is being caused to the extent that everything else has to be put on the back burner. And I understand what Gareth says, and as I said, I'm not trying to catch anybody out. But if you look at photograph 1, you know, on the right-hand side, you've got a window that has been done and made bigger. And on the left-hand side, you've got the existing window on the applicant property. And the difference is, yes, there is a difference, but it's very, very slight. And quite frankly, you know, at the end of the day, this property was built, I don't know what date it was, 1800 or 1900 and plonk. And we must allow, surely we must allow, and I think to a certain extent, Councillor Graggill makes the point. We must allow, in this day and age, to make properties that were built in a different age for, I won't say a different use, but used in a slightly different manner. Bring it up to a standard where it is a useful, habitable property. And so, Chair, I'm going to quite straightforward move, and I do this, I don't do this, it gives me no pleasure, but I'm going to move on the basis that I don't believe that there is substantial damage to this property, and I'm going to move that permission, that we recommend that permission be granted, and I so move.
Thank you. Sandra's appeared in the bottom of my screen.
Thank you, Chair. Sandra Brannigan, Senior Solicitor. Following from what Councillor Galvin has just said, Chair, I wondered whether it just helps just to remind the committee that they need to determine whether or not there is any harm. Councillor Galvin said that he doesn't consider there is substantial harm, but members need to consider whether there is no harm at all or whether there is some harm. And the NPPF tests are that if there is any harm, even if it's minimal, if there is any harm, then you have to then weigh the public benefits against that harm, and that you must give considerable weight to that harm in that planning balance. So members would have to consider, first of all, is there no harm to the heritage asset, or is there any harm?
Can I then clarify my position, Sandra? As far as I'm concerned, there is no harm to this property whatsoever by the proposals that are placed in front of us.
In that case, Chair, just to clarify, if members do decide that there is no harm whatsoever to the listed building, then there is no public benefit test. But if there is some harm, if members don't agree with and they consider there is some harm, then the public benefit test does apply.
Thank you. I wonder if I just ask Gareth if you're able to help us perhaps with because we'll need a reason for approval if it gets that far. Would it be possible to turn what Councillor Galvin said into a, presumably the reason is it
a reason for approval?
Yeah.
So you put me on the spot there. What Councillor Galvin's saying is that the alterations would not result in harm to the special architectural or historic importance of the building, and therefore, as Sandra pointed out, Sandra Brannigan pointed out, that there's then no public benefit test, so you don't have to go through that balancing exercise of weighing up harms against public benefits.
And then in that sense, basically then accords with the various other policies.
It's considered, yes, you would, yes, the presumption then is that it accords with the policies in the plan. There will be an issue of conditions that we will have to consider that clearly we haven't considered given the recommendation.
Would it be wise to?
I would suggest that yes, you recommend to the Chief Operating Officer that the decision is delegated to the Head of Development Services. I assume that with condition approved drawings, there might be some need for certain large scale detailed drawings of proposals, and there was a recommendation from the city archaeologist for building recording and watching brief as well. So those are the principal conditions that spring to mind.
Okay, thank you. Sorry, I just wanted to nail that down a bit before I asked for a second, but I assume Councillor Galvin's happy with all that.
I'm quite happy with that. I mean, that makes quite common sense. But as I say, the reason is, as far as I'm concerned, the reason is very simple, is that I don't believe that any damage is being done, and that's a good enough reason to grant permission.
Okay, thank you. So I'll just ask if there's a second. I saw Councillor Daubney's hand first, if you were going to second. Or... Okay. Would you like to speak, Councillor Daubney? Or...
Yes, please. Yes. Thank you. I do not see any harm being brought about by the lowering of the cellar floor by the amount required and the addition of a larger light well and a larger window. This has been done in other houses in the terrace, and I think it'd be quite easy to record the changes made. Photographs can be taken before and after for the record and so forth. I think the benefit will be mainly private. It brings the room into habitable use as a bedroom. It makes it safe for the occupants and the household. But yes, I accept there will be public benefits, because if a fire were to occur in that kitchen and somebody has to use a window to make a attempt to escape, there may be a need for someone else to come into the premises to effect a rescue. So I'm happy to move that the application be accepted.
Thank you. I'll take that as a second in council.
Sorry, second, yes.
Councillor Webb.
Thank you, Chair. If I'm honest, I've not entirely made my mind up whether I support the proposal or not, but things I'd like to point out, I think I do struggle to this is why I asked the question about fire safety and how that would impact on this application. And it, according to the officers who are instructors, it really doesn't have much of a bearing on this situation. What I would say is that if we take that out, then the number of public benefits, I really do struggle to see what public benefits are. This is a private dwelling, and as a private dwelling that's being altered, I'm not certain that there are public benefits. There might well be benefits to the individuals in the property, but that isn't the case. In terms of what Councillor Craggill was saying about making a more a greater stock of family housing, well, this is already being used as a family house, so I'm not certain that we're increasing that as a public benefit either. So then we come on to, okay, so if I assume that there's no identified public benefits as it states in the report, then I suppose we've got to think, are there any changes? Because it's the word harm is important, but in this case, when we're talking about architectural changes from what is a listed building, then it's the change that is classed as harmful, I believe. And whilst we've talked extensively about the basement and the fact that the basement will be lowered slightly and changed and a new light will be put in, what we haven't talked about is that actually higher up the building there's going to be a new petition, there's going to be an entire new staircase put in, and essentially another room built into this house. Now that is clearly definitely a change to this property from what it was. And my final point, I suppose, would be, and I think I am coming down actually with officers on this one, the more I'm talking, the final point for me would be that if we have got that change and there are no public benefits, we have to go with the MPPF. Now, in the past, as we've been informed tonight, councillors and officers were working to a different set of criteria, and therefore they could come up with a different decision, which they clearly have in the past. But I'm not sure that we have the grounds to actually make that same decision. I think we're in a situation where we've kind of got to go with the officers, despite best interests, and despite what Councillor Galvin said, with most of which I agree with, but actually a lot of what we've got here written in front of us, and from what we've seen tonight, really does prove there isn't really much of a public benefit. And there are changes to this building, and you know, the policy is the policy. So yes, it's a tough one, this one, but I'm not at the moment certain I could agree with Councillor Galvin.
Thank you. Councillor Cracknell.
Thank you. I wasn't sure I needed to say anything till Councillor Webb gave his bit. I really think that I support Councillor Galvin's proposal, and I really think that what's proposed alternatively in the paper is really kind of, you know, very worrying in the sense of the planning system really being shown up as the enemy of common sense. This is an application that has no objections. It has support from neighbours and support from the local planning panel. And in my view, and I realise that, you know, after that we have to look at these specific planning issues we've been talking about. But I would agree there is essentially, happy to agree that there is no harm to the building. In my view, the appearance of the front elevation that's proposed is an improvement. It makes the terrace look consistent rather than the current arrangement, which looks rather incongruous. The paper acknowledges there is an improvement to the appearance at the back of the building by replacing the existing extension with a new one. That's in the paper already. I don't agree with the Conservation Officer that the petition to access the attic is not reversible, and we've made other planning decisions with similar concepts that have been actually recommended for approval because that sort of thing is reversible. And just overall, I think the improvements, you know, the fire issue is a difficult one in of itself. I totally recognise all the comments that have been made, but actually at the moment, it may be being used as a family home because sometimes people don't have the choice that they would ideally like, but it's obviously struggling to be used as a family home. So I do think it is valid to say that it also adds to the addition of family homes. But obviously I'm aware that if we say there is no harm, we don't actually have to weigh the benefits. So I think, you know, I can certainly support approval on those grounds.
Thank you. And Councillor Fisher, and then I think we're ready to.
Thank you. This puts me very much in mind of 10 Vicarage Lane, Navan, as some of you may remember, which was a row of houses where every single one bar one had been extended prior to the 2018 local plan being introduced. And then suddenly the poor guy comes in, wants to bring his family in and wants to put a modest side extension on. And we refused it the first time round because the local plan, the neighbour is washed over by the greenbelt. So it was harmful to the openness of the greenbelt. And this looks pretty much the same to me, where in fact a local planning matter is getting a bit in the way of common sense. So it all depends on whether we consider that these proposals harm the building. Now, I look at page 22, article 514, where it says about lowering the floor would harm the fabric and historical interest because this room was once used as a store. Well, at one time we used to have people living in, you know, having stables in the same room as them. We don't do that anymore, and I don't see why the fact it was once used as a store has any bearing on it at all. Putting the new window in at the front harmonises that row of houses very nicely. At the moment, number 14 looks out of place with the others. I think a new window and an enlarged light well will actually benefit it. We've got the loss of the sloping roof at the back. The rear extension is better. On balance, I don't think it does harm to the building, and consequently, I think I will be. I was very, very much in two minds, and I worry about going against officer recommendations. But on this occasion, I think the balance is actually that we should support this.
Okay, thank you. I can't see any further. Councillor Galvin, you want to come back very briefly because I think we're ready.
All I was going to say was, reading the report, I'm fairly certain that the internal alterations, with the exception of the basement that seems to be the centre of discussion, could be taken out and put back anyway. I'm not stressed about that at all. I think that could be put right in the event that somebody wants to turn it back. But Councillor Fisher makes a good point. He's right. You know, we used to have beds, people sleeping with horses. We don't have that now. And I think you can use that same kind of analogy. But anyway, there we go. Leave it at that.
Thank you. I think we're ready then to move to the vote. Gareth, if you could give us a quick summary of what we're voting on, and then Jane, if you're able to conduct the vote.
Thank you, Chair. So it's been moved that, let's get this right, for a subcommittee to recommend to the Chief Operating Officer that list of building consent be approved, but that delegated authority is given to the head of sorry, I've got no title. Head of Planning Services. Head of Planning Services. Sorry, I'll get that in the neck. To devise the planning conditions on the basis of the submitted drawings and consultation responses.
Thank you. And Jane, if you're able to.
Thank you, Chair. I'll ask you to vote in alphabetical order. Please state if you are for, against, or wish to abstain. So Councillor Craghill.
For.
Councillor Daubeny.
For.
Councillor Fisher.
For.
Councillor Galvin.
For.
Councillor Melly.
Against.
Councillor Orrell.
For.
Councillor Perrott.
For.
Councillor Wardby. Against. Councillor Webb.
Against.
And Councillor Hollier.
Against.
Carried. 6-4.
Yes, Chair, it's passed 6-4.
Okay, thank you. So that is passed. If we take a 5-minute break before the next item, so perhaps if we aim to go back about 6:10. Well, thank you and welcome back, everybody. Welcome back as well to Councillor Crawshaw. Move straight on to item 4C, Gareth. Sorry, everybody's moved around on the screen.
Thank you, Chair. So this is an application at land to the north of 21 Main Street in Copmanthorpe. And it's for the erection of a detached dwelling. For a short presentation, I will share my screen. Apologies. Let's go back to the beginning. There we go.
Excuse me, could we possibly compact the view of our members so we can actually have the presentation a little bit bigger, because my eyesight isn't all that wonderful still, and consequently I can't see it when it's that small.
Go up to view and check it on view.
I think we might be able to get advice from Richard.
Sure.
If he's struggling,
It's
but we should be able
Richard from the technical team here. Councillor Galvin gave the correct advice, which is to click on view, and then you get different in the top right of hand corner of the main screen, and you get different options.
Thank you. I hadn't realised that changed anything from the previous one, but now we're fine. Thank you.
Carry on then, Gareth.
Okay, so the site is set out in red on that image. So residential dwelling at number 21 to the south. I think this site was the former garden of that property. The Methodist Church to the north, residential development to the rear. Site is in the conservation area. So the proposal, I'm afraid some of the drawings are a little bit busy. So the proposal is for this 2-storey house to be constructed in the garden. Sorry, no, it's in this plot. So just going around the outline of that, so you can pick it up. The Methodist Church and the adjacent dwelling. Site section there shows the property with measure drawings of its neighbours, taken from the front, from the main street. There's the elevations and the floor plans. So we have 3-bedroom dwelling. And these are some more sections again showing how it sits on the plot and its relationship with the neighbours. So number 21 sitting forward of the front elevation of the proposed house. There's some photographs. So that's number 21 Main Street, Methodist Church, the plot here. Members will have seen from the, I'll just move to a separate one. So members will have seen that the proposed property shares the driveway, the access way rather, with number 21. It's the Methodist Church, the side entrance to the Methodist Church with the site here. And then the gap between the Methodist Church and the application site fence. Just go back to that, the site plan. So you will have seen in the papers, the property has a in curtilage car parking space, but the manoeuvring is, and entrance access to that car parking space is from this shared drive between number 21 and then the new house. You can manoeuvre in and out in forward gear. We do have an update on the papers that were forwarded to members earlier on today. There's an additional letter of objection regarding some of the conditions that have been recommended. Then there's an officer comment on those three, the conditions that have been raised. And just the confirmation in that final paragraph that we've had confirmation from the applicant that he accepts the conditions, considers he has sufficient legal rights to complete the development, and then a comment that the grant of planning permission that doesn't override private property rights, and ultimately, should the applicant not be able to implement the conditions, they'd need to bring forward alternative proposals and possibly apply for the conditions to be removed or varied, and then that removal or varied is ultimately in the hands of the local planning authority in terms of whether to grant any amendments. Do members wish to see any of the images or photographs again, or should I stop sharing?
Can't see any hands being stuck up this time, so I think you can stop sharing, and as before, if we move straight on to our public speakers before coming back to sort of officer questions afterwards. So if Parish Councillor Lars Cram, if you're...
Thank you, Chair.
Thank you. Yeah, I'll just say you've got 3 minutes to address the committee. I'll give you one in about 30 seconds.
Good evening, councillors. I'm here to emphasise Copmanthorpe Parish Council's strong objection to this application, and I'm also entrusted by Methodist Church trustees to highlight theirs. Let me start with pointing out the misleading inconsistencies between the site plan provided, which shows clearly the boundaries of the site, and the site plan provided in the presentation, which has incorporated the drive of number 21. There is a right of access, but it's not part of the plot. The drive should not be included in any assessment of overcrowding, open space, or overdevelopment. We are not NIMBYs. Our parish is not a frequent visitor to this committee, and our ward councillor is not overzealous with call-in request. Villagers accept house building is needed, and 2 large sites for housing development are allocated in the draft local plan and included in our draft neighbourhood plan. This house is not needed to meet housing requirements under 69 NPPF, but serving the village as a green open space is preferred in line with policy CNP 7 of the draft neighbourhood plan. Developments we are strictly opposing are those that affect the core of our village identity and our village community. The Methodist Church is one of the pillars of our community and an important venue and hub for community events, groups, and activities. The church highlights several material considerations and outlines the detrimental effect of the development on the church. I would like to draw your attention particularly to the overshadowing effect and loss of light. The side access, garden, and several windows will be deprived of an acceptable level of light. As the Law Commission's report on the rights to light highlights, local planning authorities need to consider the effect of new buildings upon the natural light value of existing structures. The planning system gives protection, and I quote, "A local planning authority will want to see evidence of the effect it will have upon the neighbouring properties, including, in many cases, the light and other amenities that those properties currently have." End of quote. To our knowledge, no evidence on the impact of the natural light has been provided by the applicant. Our village design statement also requests from infill developments such as this to be good neighbours and to retain neighbours' right to light and privacy, which of course applies to all neighbours, left, right, and behind the development. Additionally, the church paved area provides a safe, secure play area for preschool children who use the premises for approximately 15 hours a week. Government guidance indicates that material consideration relevant to the best interest of children should weigh heavily in any decision. 2/5 of the blank side wall will overlook the church patio area. The detrimental effect of the potential loss of this area to the children's use is a persuasive reason for refusal of the application in its own right. As ward councillors, you will be too familiar with the conflict between community halls and neighbouring properties. The church is registered for live music and other performances up to 10:30 p.m. Copmanthorpe Parish Council outlines in its objections 15 violations of policy of our village design statement and 7 further conflicts with planning regulations. I'm happy to provide further explanation of any of them. As you do not have the benefit of an essential site visit, please just look at the map. This garden is not a building plot. This is a poster boy of an intrusive, unacceptable, crowded overdevelopment in our conservation area. Thank you.
Thank you. And if there are any questions from the committee to Councillor Cram? I can't see any, so I'll thank you for your time this evening, Councillor Cram, and you'll know you'll be able to continue watching on the YouTube channel. We can move on next then to Philip Watson, to local resident speaking in objection. Can you hear us, Mr. Watson?
Can indeed. Can you hear me okay?
Yeah, we can hear you fine. And
all right.
Third, you've got 3 minutes to address the committee. I'll try and give you a sort of warning, about 30 seconds to go. But yeah,
thank you very much.
Start in your own time.
Good evening, Chair and members. So the land is currently amenity space. It contributes to the character of the village and streetscape. It provides ecological and biodiversity. The application was filed legally incorrect at section 26 and sought to purposely or otherwise hide or mislead the council as to the true ownership of the land. The application is made by a local developer purely for maximum financial gain. This is reflected in the scale and massing of the building, which is disproportionate to the site itself, a fact that the design and access statement acknowledges. The application at section 5 described the building as a bungalow, which is clearly erroneous. The application states 2 cars, but the drawings only depict 1. The initial application and design sought from the outset to, at best, disguise or at worst, totally mislead planning officers and the council, presumably recognising the tenuous grounds on which the application is based. The design itself contravenes numerous planning policies, including the local plan, the City York Development Control Plan, and the Copmanthorpe Village Design Statement. This disproportionate dwelling detrimentally affects the appearance of the conservation area, reduces the ratio of green space, fails to complement existing buildings, contravenes that front gardens not be dominated by hard landscaping and car parking. Effectively, it overdevelops the space. From a neighbourly perspective, it abruptly encroaches on the privacy of 21 Main Street. To the rear, the first floor glazing, an architectural indulgence, looks directly into the bedroom of 12 Deacon's Court. This property has not been afforded any protection through suggested planning conditions. Rights to light, as afforded through statute and the Rights of Light Act 1959, have been compromised. The building is impractical in use when consideration is given to the lack of access around the perimeter, recycling and refuse inadequacies, insufficient parking and vehicular tracking, which brings me on to my final objection heading, namely the risk posed to the health and safety of pedestrian and drivers. The building is adjacent to the Methodist Church, which we've seen, which hosts children and community events, directly fronts a T-junction, lies on the main arterial route through the village. Parking is already in short supply. To bring additional cars onto Main Street and worse, provide inadequate and blind reversing onto a main road will, in my mind, cause a serious accident. Indeed, the development was not initially supported by highways for the above reasons. I acknowledge visibility displays have been imposed as a condition of planning, but they are not within the gift of the developer. And how will they be maintained in perpetuity?
You're able to wind up.
In summary, the proposed development is designed for maximum commercial gain and is not in the interests of the community. The application sought to mislead from the outset. The scale and massing is disproportionate to the size of the site. The proposed development contravenes planning policy. It significantly erodes the privacy of its neighbours. It creates a potential traffic hazard. I would ask that safety and the adverse impact on the local community be put above commercial gain and this application be rejected. Thanks for your time.
Thank you. And if there are any questions from the committee, I'll Councillor Crawshaw.
Thanks, Chair, and thanks for speaking to us this evening, Mr. Watson. I just wanted to double check on the privacy issue, and I appreciate the property at the rear. For the properties on either side, the church and I think it's number 21, you said, is the privacy issue around windows, or is it something else? What's the nub of the privacy issue?
I believe certainly I can speak informatively from the property at the rear. There's a glazed first floor window that looks directly into the bedrooms of 12 Deacon's Court. There's plenty of objection letters on the council website pertaining to 21 Main Street, where windows do look directly into the adjacent property. Now, I believe planning conditions suggest opaque glazing, but nevertheless, they do, and how will that be maintained as well? So there are privacy and dignity issues to the whole circumference, in my mind, of that proposed development. But it really is about the massing and size of the building that they're trying to squeeze onto a postage stamp size site.
Thank you.
Thank you. I can't see any further questions, so I'll thank you as well, Mr. Watson, for your time this evening, and similarly you'll be able to continue watching on the YouTube channel.
Okay, thank you.
If we could hear next then from Andrew Peart, who's from Gately Legal. He's the agent from the applicant.
Thank you, Chairman. My camera says that it is stopped by you at the moment, in case members can't see me.
I haven't specifically done anything. If you don't mind just continuing off camera.
Certainly. The site, Chairman and members, is an unused piece of private land, which is sustainably located in the centre of Copmanthorpe, close to shops and services. The proposal is for a single house whose simple design is carefully conceived to ensure that it integrates into the street scene and with the conservation area's character. The property is lower in scale and size than either the Methodist Church building to its left or the semi-detached house to its right. It is situated 23 metres away from the property to the rear and has parking which is accessible in forward gear. In preparing the design, regard has been had to the City Council's policies and also the Village Design Statement, as well as national policy which supports the development of infill sites in sustainable settlements such as this. The Village Design Statement notes the character of the area as one of buildings set close to one another, facing the road, with access to gardens and space for maintenance and parking, and the scheme submitted reflects those characteristics. The conservation area appraisal characterises the area as comprising two-storey houses and cottages on narrow frontage plots with the use of brick. And this building responds to that and reflects the variance in building lines and eaves levels that is characteristic of the conservation area. This is a bespoke, a freestanding design, integrating well into the street scene with subtle variation in character and interest, consistent with the variety that is part of the character of this area and in common with other properties in the conservation area set back behind a hedge. The detailed design of the building has given very careful consideration to its relationship with its neighbours. The side elevation of number 21 is a predominantly brick gable separated by the shared driveway over 4 metres in width. The elevation facing number 21 has windows and roof lights, but the windows will be obscure glazed and the roof lights are set above eye level. The elevation facing the Methodist Church is a blank gable to ensure mutual protection of amenity and maintenance of the intimacy and privacy of the spaces and the usability of the spaces surrounding the church. Overall, this is a modest building which provides a new element of interest into the subtly varied character of the Main Street, consistent with the policy principles and the Village Design Statement, in an appropriate and a sustainable location and which respects the amenity of its neighbours and members are therefore requested to grant permission. Thank you, Chairman.
Thank you. And if you just hang on a minute, I'll just ask if the committee have any questions. Councillor Crawshaw.
Thanks, Chair, and thanks again for coming to speak to us this evening. I just wanted to double check your understanding of the access on the lane, because I think that there was a suggestion that the lane not being in your ownership therefore meant that there was possibly an issue around access. Do you know what the access rights are to that lane currently? Because I don't believe it's adopted highway, it's a private lane, is it?
The access way between number 21 and the plot that we're talking about, my clients own rights of access over it, so they can drive in and access the parking area within the plot, which is laid out so that can be done within first gear, and the rights that my client has enables them to satisfy the conditions that the officers have proposed regarding the access.
Thank you. If I may, Chair, I've just got a second question as well. Thank you. The other issue that was raised was around the current existing use of the Methodist Hall, Church Hall, and that they can sometimes do events till later on in the evening. Has any consideration been given to ensuring that the new residents of this property are not either unduly disturbed and therefore, potentially impact on the existing activities of the church?
Yes, Councillor, it has, and in particular, the elevation of the building which faces the church does not have any windows in it. So that provides additional noise insulation for the occupants of the proposed new property, and obviously mutually protects the ability of the church to carry out its activities without causing harm to the new neighbour.
Thank you.
Thank you. I can't see any further questions there, so I'll thank you as well for your time, Mr. Peart, and similarly be able to continue watching on the council's YouTube channel. We'll take your comments into account as we move forward.
Thank you, Chairman.
Thank you very much. If we could move on then to questions for Gareth. Can't stick your hands up. Councillor Fisher.
Thank you, Chair. One of the things that I asked yesterday was about the ability to store wheelie bins at the rear of the site and get them down the side of the building. Now, when I asked that question, I was told they could be done, they could be moved over the shared drive. Presumably that was saying to get them to the front of the building for collection. Looking at this, I noticed that on several of the plans, there appear to be fences between 21 and the plot. Now, can officers confirm, please, that the resulting gap between that fence and the building will be sufficient to get a wheelie bin? Because one of our SPD recommendations is that all buildings should have a method of getting wheelie bins to the back of the house. They don't have to be stored at the front.
Yes. Can I bring the case officer in? Kevin O'Connell is on the line. Has a deeper knowledge of the drawings and the proposals than I do.
Thank you, Chair. Yes, I'm Kevin O'Connell, the case officer. Can you hear me all right? Hello?
Yes, we can.
Although the photograph shows that there are gates along the drive, the drive goes all the way to the back of the site, as you can see from the plans there, and there will be railings between the building and the drive, but the occupiers of the new house will be able to store bins at the rear of the site and trundle them down the drive to the front, and they could even be stored overnight or whatever during on bin day off the public highway and out of the way of the drive. But there is the rights we understand that the applicant have include right of access in perpetuity for pedestrians, a car to the access, and for going in and out to the rear garden.
Okay, thank you. Councillor Orrell.
Thank you, Chair. Gareth, what weight can we put on the Copmanthorpe Village Design Statement and the draft neighbourhood plan? What weight can we give to those?
Thank you, Councillor. The village design statement was approved by City Council in 2002 as a supplementary planning document, which gives it weight as a material consideration in the decision-making process. The neighbourhood plan hasn't yet been submitted for examination. It has gone through public consultation. It's not yet been accepted by City of York Council. So whilst it has some weight, I would say that weight is limited. I understand the village design statement was updated as part of the neighbourhood plan process in 2018. So it's part of the neighbourhood plan. So I would say it has the same limited weight in terms of part 2 of that neighbourhood plan.
Thanks, Gareth. And the right to sunlight and light is mentioned in one of the objections. Is that relevant? And is there a difference between the two?
Well, rights to light is a private matter. It's also a material consideration in the planning process to be put in the planning balance with any other material consideration, and we consider overshadowing of properties as part of the planning process. The planning authority granting planning permission, having taken into account any overshadowing or loss of light issue, wouldn't then override any private action that an adjacent householder might, an adjacent landowner rather, might take in terms of private rights to light.
Thanks, Gareth.
Thank you. And that would apply the same as if it was a dwelling house or a church in this case?
I believe so, yes.
Councillor Crawshaw.
Thanks, Chair. I was also going to ask a question relating to the lights. You've partly answered, I think, already, but I just wanted to be clear whether there was any difference in terms of internal light in a building versus external light in an open space. Because I think if I'd understood it, the point that the first speaker was making was that the outdoor area as a patio is sort of used for children and young people, and that their access to light there might be impacted. And I think we normally tend to think of right to light as being the light inside the building that comes through the window. And I just wanted to sort of understand if there was a difference, or even if external light is considered in the same way that you might do an internal right to light.
I think it's certainly a material consideration. It's just how much weight you would give to it in the planning balance. The impacts that we normally give more weight to impacts on light to habitable spaces in dwellings, and give less weight to non-habitable spaces like bathrooms, circulation areas, things like that. In terms of external areas, garden areas, it's something that can be taken into account. I think there are different considerations when looking at non-residential garden areas. And I would say that would be, you would look at how any impact would have, what any impact would have on the overall functioning of that building. You know, would overshadowing of a patio area or a circulation area outside a commercial building or a public building, like for example the church, would that adversely impact on the ability of that building to function in its purpose?
Thank you. If I may, Chair, there's just another quick question. Thanks. Apologies if this was something that was seen on the site visit. I wasn't able to attend yesterday. I could see from the photograph of that outside area that there were windows within the church building along the wall that faces the development site. On the plan, there's then a section of the church hall which looks to be much closer. I think if it was a traditionally laid out church, it would be the nave of the church, as it were. Are there any windows along that section that you know of at the closest area of the church to the site boundary?
Kevin, could you come in with that on that one, please?
I've hopefully be able to see me a bit better now than you could just a minute ago. Yes, there are three slit windows, if you like, that on that elevation closest to the application site. I haven't been into the church, but I have looked at the plans on which the extension was based, and the area behind those three windows is a stairwell, and it's not part of the main area, congregational area of the church.
Thank you.
Thank you. Councillor Cracken.
Thank you. My question was really partly along the lines we've touched on in relation to the outdoor area and of the church and the overshadowing that was mentioned. Perhaps you could just, following on from what's already been said, could you just clarify for me how much is it overshadowed? I'm not great at this north, south, east, west business. Could you clarify? Is it totally overshadowed by the building? How has that been looked at, particularly in terms, of the impact of the use for young children's play sessions?
Shall I answer that? There is a photograph, Gareth, that shows the area. If you could put that up, if you can you? There's if we see that photograph, you'll be able to get the best I can manage on the
Chair,
on what the impact will be.
Are you happy for me to share the screen again?
Yeah, please. Do you need me to?
No, I can do it. I just be helpful if I click the right button. Sorry, bear with me. Is that the one you meant, Kevin?
That's the one. That's the that is the side entrance to the church, but I understand it's used quite a lot. That is the patio area that excuse me, that has been discussed and that is currently used. Those benches face south, so they certainly benefit from direct sunlight at certain times of the year or certain times of the day, and you can see that they are used. You can see over to the right there the fence, and the building would be about on average a half to a metre, less than a metre I expect, from that fence, which and the eaves height on that elevation there, that side of the building, would be, I guess it's slightly above that that band, if you can see on that the wall we're looking at, there's a sort of a slightly different coloured band part way up. It would be maybe 1 or 2 courses above that. That's where the eaves would be, and they would be about 0.5 metre to 1 metre the other side of that fence. So the use of the site of that patio wouldn't be affected at all. The access to it, there would still be that landscaping between the fence and the path, but there would be some loss of direct sunlight, because particularly in the cooler months, because of the height of that gable, of that side elevation, which would have no windows in it. But that's in our view, that wouldn't be sufficient to justify refusal.
It might help members to refer back to page 89 of the agenda papers, which showed that site section AA with the measured drawing of the Methodist church adjacent to it, and then the proposed site plan as well shows, I think illustrates that relationship quite well, and the photograph in front of you.
Yeah, thank you. Chair, can I ask another quick question on something completely different?
Please do.
Just could you confirm for me, I may have missed this, I did last time, is there a construction management plan in the conditions? Because obviously it's a very tight site, so if it were to be approved, it might be a good idea.
I think there's an hours of construction.
Is there? Where is that?
Condition 15.
Oh yes, there is. Yeah, there's hours.
Yes, with single plots, we don't tend to recommend construction environment management plans.
Yeah,
doesn't mean members
considering on, given.
Well,
it's
it's for members
plot.
it's for members to consider. We've already considered that we wouldn't recommend it, but I take the point in terms of the site, the tight site.
Yeah.
Thanks. In terms of the light to that point, I mean, I'll try this. It might be a little bit crude, but is there actually any? You sort of see the line I've drawn from the top of the. Would there actually be any loss of light if essentially, in terms of that sort of line, you couldn't, it doesn't seem to be actually blocking any further light? Does that make sense?
Yeah. I'm going to have to think about what the document says. I mean, normally in terms of sunlight, you draw a 25-degree line, but then that's from a point, not from ground level. You would draw the point further up, but that tends to be in terms of impact on windows, and you have to take into account that 21 has its gable facing. So whilst you've run that line through the ridge, because you'd be looking at the end of a gable where the roof will fall away to some degree. So there will be, the sunlight will, depending on the time of year, work its way around that roof. But similarly, it's I think it's pretty much on a north-south, on a north-south axis. So certainly in the summer months, the sunlight is likely to be, because of the height of the dwelling, is likely to permeate over the roof. And then when you get into the afternoon, then the impact of the dwelling is probably reduced completely, because it's moved around across Main Street. So Kevin, is that what you were going to add to?
Yeah, I couldn't add much to that, except that we are talking about direct sunlight, of course. I don't think there'll be any shortage of light to the to that patio. It'll be perfectly usable, but they do lose at times they're likely to lose some benefit of direct sunlight, which they enjoy at the moment.
That explains that. Councillor Fisher.
Thank you, Chair. We heard from Councillor Fram that the Methodist Church is obviously very well used. It's a pillar of the community, and that activities do sometimes go on, including music, till late at night. We heard from the agent that the mitigation measures to prevent nuisance to the occupants is that they've put a blank gable wall with no windows in it. Now, what worries me is if that mitigation doesn't prove sufficient and there is a noise nuisance to the occupants, can you confirm that the Methodist Church will be covered by agent of change legislation, and that any further works required to mitigate the nuisance from the activities would fall upon the future occupiers?
We can't eliminate the rights for people to make a complaint about loss of amenity under public nuisance. Kevin, we did consult with public protection on this application, I believe 3.2 in the report on page 70, and they did not raise any objections in terms of this, and they would have looked at it in terms of potential for noise nuisance, and they would have recommended a condition if they felt that was an issue.
Can I just bring
Chair,
sorry.
If I was just going to say that the activities that go on, I don't know how frequently, later into the evening, they would be inside the building. And we are talking about two substantial buildings here, and with a gap in between. I wouldn't have expected the activities within there to cause a significant nuisance to the occupiers.
But it just takes me back, and Councillor Crawshaw will remember this very well, to the Crescent and the application for conversion of some flats next door, where there was considerable concern about whether or not the activities that carry on there presently, quite legally, would be impacted on by the change of use of the neighbouring dwelling. And that's what concerns me, because obviously if the Methodist Church wants musical activities later at night, which it currently enjoys, it should not be down to the Methodist Church to mitigate against the noise nuisance, because they're doing what they're doing quite legally. Surely it should be down under agent of change rules to the occupier.
Yeah, I would say that that's been taken into account,
right,
through the design of the building and through the comments from public protection. Obviously, the Crescent is a late night live music venue, and the affected building next door was and they're essentially two Victorian buildings, whereas these are the Methodist Church is of more recent construction, and this would obviously be built to current building current building regs in terms of put myself off now in terms of its construction.
Thank you.
Okay, Councillor Daubney.
Thank you, Chair. I understand the gap between the proposed building and the the boundary of the site is going to be between 0.5 metre and 1 metre, which seems quite tight to me. Can I ask what the gap is going to be on the other side? between the boundary fence and the building. Thank you.
Sorry, Chair, Councillor, could you just bear with me a second? 4.1 metres from the adjacent house, number 21. That's what I have.
And what is it, please, to the boundary of the site on that side?
It would be a little less, but not very much, because the railings will be coming quite close to that southern elevation of the proposed house. Are we talking about the same thing here? Have I misunderstood the question?
I think you have. Put it another way. On the side which will be boundary number 21, how far will it be from the proposed building to the extent of their land, their railings?
Well, it was, as I said then, it would be just not very much less than 4.1 metres if the distance across the drive is 4.1 metres. But if we just look at
Kevin, the question is, what's the gap between the flank of the new building and the boundary between the two properties?
Well, not.
So it's not going to be 4.5 metres. No. It's going to be.
No, the distance between the two houses would be 4.1 metres. If you look at the site plan, the railings would be along the boundary, which is not very far from the front elevation of the proposed house, or that long elevation that's facing number 21.
Yes.
So it mostly stays as the drive of the number 21.
I think negligible
is
the answer.
That still didn't answer the question.
Yeah, I think about a metre, but I'm just guessing. This is what I wanted to be.
I would say well, there's a step in the front elevation. If you look if you're able to get the site plan up, there is a step, and so that the front part of the section nearest the road, nearest the highway, is further from the number 21 than the part of the house further back, and the fence line will go pretty much or very close to the front elevation. It's marked in red on the site plan. If you're able to get the site plan up, you'll see that it's we're not talking about very much when it comes to being compared to the wide part of the house, but the section is about 1.5 meters where there's a cut in it, a cutout. It's a bit hard to explain, I'm afraid, without the plan in front of me, in front of us all.
I can see the plan. It looks so narrow to me. I'm suspecting between 1 and 1.5 meters at the most.
Yes.
But
yes.
Thank you very much. Thank you.
Okay, Councillor Fisher, you got a supplementary?
Sorry, I'm not sure we're comparing like with like here, what we want. What I actually want to know is the new building that is proposed, forget number 21, how far is it between that house and the fence which forms the boundary between the new property and number 21's curtilage? That's what I actually want to know. In other words, not how far it is from 21, but how far it is from the boundary between 21 and the new property. That's what I'd like to know, because
if you're able to see the site plan, in the wider part of the house, the gap would be negligible. At the narrower part of the house, it would be between about 1.5 meters.
Thank you for that. That's what I need to know.
Okay, Councillor Galvin.
Chairman, I think mine should be fairly easy to answer. If we're standing on the car, where the car's parked, in other words, turn the plan upside down as we have it on page 89. we're given to understand that notwithstanding the roof lights, there are no windows at all on the left-hand side, i.e. the boundary wall facing the chapel. On the right-hand side, I think we were advised yesterday that all the windows on the right-hand side would be opaque glass. Is that in essence the case, or leave the roof lights out? I mean, they're slightly, for the purpose of the question, slightly irrelevant. Are they all opaque on the right-hand side, looking up the site from the car park?
Facing towards number 21.
Yes.
Yes, they are.
All the way up from...
And there is a condition that requires that.
So what we're really saying then is that there is no, I use the word view, no outlook whatsoever from any window on the upright walls.
Not a clear view. But there will be a view, but the glass will be obscured. So yes, you'll get the benefit of light, and you'll be able to see something through it, but you won't be able to see anything meaningful.
Thank you.
For info, it's condition 11 on page 80, if you want to see the exact wording.
Sorry. Yeah, well, I was just confirming.
Yeah. Okay, thank you. I can't see any questions at that point, so if we're happy then to move to debate, I'll invite you if they'd like to kick us off. I've got Councillor Crawshaw and then Councillor Webb.
Thanks, Chair. I think it's always one of me or Bob that kicks things off, it feels. I find myself looking at this plan and feeling a sort of two different things in one go. On the one hand, I think actually it's probably quite a clever use of space, in the sense of, if you look at the plans, all of the internal ground floor rooms along the side are the sort of utility type rooms, and on the first floor again it's utility or wardrobe or what have you, with then the sort of rooms at the two ends of the building being where the principal light and view comes from. So in that sense, I think it probably is quite well designed to fit on the plot that's available. It's clearly a very, very narrow plot, and I can see why the residents and the neighbours on either side feel uncomfortable about having a plot sort of infilled in this way. And I think, my general feeling has always been that I find infill difficult, because I think that it is about profit. It is about somebody taking a piece of land and thinking, I can maximize the profitability of this little plot of land I've got by sticking something in there and selling it on, and I don't need to worry too much about the neighbours as long as it meets all of the appropriate legislation. I haven't heard anything that would give us, to my mind, a robust reason to refuse this application. I'm going to just reserve judgment before proposing anything in case I've missed something and somebody comes forward with a really strong argument for why we should refuse it. I can see lots of reasons why it's uncomfortable and why we might want to refuse it, because it is that, using up of every last little bit of space. That's not really how we all want to live in the city. But as it stands on its own, it's quite a clever use of the space, I think. And I can't see what robust grounds we would have that wouldn't just be overturned at an appeal if we were to find something. But please do present me with something if you think that there is grounds.
Okay, Councillor Webb.
Thank you, Chair. I'm going to be slightly more forthright than Councillor Crawshaw, in the sense that I agree with what Councillor Crawshaw's just said, that I don't really see, I think that the issues that we've discussed in terms of potential loss of light and loss of sunlight, I think the effective visual amenity on neighbours, I think, has been taken account. I mean, Councillor Galvin asked a question at the very end that sort of dealt with that. So in fairness, again, I don't really see how we can disagree with the officer recommendation, because I've not really seen any evidence for that. I also agree that infill can be tricky, and you know, I do want to put resident amenities before profit, pure profit, but in this situation, we have to go with, you know, the evidence in front of us, and I think I'm struggling to see a reason why. So I will propose to accept the officer recommendation, and challenge anyone to second it. But you know, and then we can go from there, can't we?
Okay, well, I'll just pause there and ask if anybody is willing to second it. Stick your hand up. Can't see anybody immediately.
Well, that's got that out the way then, hasn't it? There you go.
I'll tell you what, I'll second it.
Oh, that's kind.
We do have it has been moved and seconded, but we'll go to Councillor Galvin before we go to the vote.
Well, I think you've got Councillor Fisher as well. Chair, over the years, and certainly this last few years, we've been on a number of what we might call tight site developments. And I don't think, in all honesty, we've ever come across a site as tight as this. I was looking for a phrase, and it was, I think it was one of the speakers, it was, I think, last speaker that made the point. This is totally disproportionate to the site. I just find it unbelievable that we're looking at giving permission to put a building in a site that's probably got 1.5 meters either side of the property, between the property and the fence. A house that certainly on the two sides of the house have no clear vision. One wall is completely blank and the other windows are all opaque glass. And I suspect that in the fullness of time, those opaque windows will be reglazed in clear glass. And so I, quite frankly, I can't give any reasonable argument to agree to planning permission. And I would submit that we can turn it down on the well-known phrase that's often used is overdevelopment of the site and disproportionate to the site. I suppose the two are the same, plus the effect it's going to have on the neighbours. So I'm dead against this development, Chair. It has been moved and seconded. I was waiting to see, I was quite prepared to start it off, but I thought, well, I started the last one off. I'm not going to start this one off as well, because on Councillor Fisher's, Councillor Crawshaw is partly right, but I seem to be also one that moves fairly early on. So I really do hope, Chair, that this is not granted permission. Okay, we will not be the final arbiter if this authority refuses permission, and I would be. This is one of those that I would be interested to see how it will be dealt with actually by an appeal. But so be it. It is totally out of character as far as I'm concerned. And as to the village design statement, interestingly, I think Copmanthorpe was the first village in North Yorkshire in 2001, 2002 to put a design statement together. And that's sort of been overtaken by other things as well. So, no, I'm sorry, I cannot for the life of me support this development at all.
Thank you, Councillor Fisher.
Thank you, Chair. I'd spent quite a while bearing in mind what it said in the conservation area appraisal, that the main street is characterised by dwellings on very narrow plots. I actually spent about an hour, because I'm a SAP person, looking around on Google Maps last night, trying to find any plot anywhere in the sort of conservation area of Copmanthorpe that was as narrow as this one and constricted as this one. And I couldn't find one anywhere. The nearest one I could find was about 50% wider. And that suggests to me that this plot is just too narrow to actually cope with the dwelling. Looking at the actual areas, I did some very rough, I asked the officers, but I did some very rough Gareth Arnold using pencil and, Google Maps to try and get the actual size, get the spacing. And I make it about 3/4 of a metre on either side, which to me is very, very close to the boundaries. And I just cannot support development on this site. I think if it could go to appeal and then let a planning inspector, but I'm not prepared to vote for it at the present time.
Thank you, Councillor Webb.
Thank you, Chair. I want to firstly clarify, it's rare that I'm on the side of the developers. I think one of the things I'd point out is we've got to look at the law, the planning law, and I think that we've got the boundaries of the site, and we've got someone who's building something that comes up to those boundaries, and I just think we have to look at what's in front of us. And I think from what we've seen, I can't see a clear reason for refusal. And remember, if you don't agree with what I'm saying, one of you's got to come up with an actual reason. And I know we've said overdevelopment of the site, but I'm not sure that would actually apply. And then both Councillor Galvin and Councillor Fisher have turned around and says, oh, and maybe this will come to appeal, and then we'll have to let the inspector deal with that. That'd cost us if the appeal was lost, though, wouldn't it? That's York money, isn't it? And I think that's something that is a shame that we have to consider such things, but I think it's important given that officers are recommending approval. So I think, if you're going to think otherwise, be thinking why you're going to refuse it.
Thank you, Councillor Crawshaw. Councillor Crawshaw.
Thanks, Chair. Just briefly. I'm listening, and I'm still hedging at the moment, but I don't see. If you look at the windows that are on the side, they're the windows to a walk-in wardrobe, to a toilet, to another. I think looks like another sort of bathroom toilet. So there's only the two windows at the back, the kitchen window and the window next to the dining room on the side, that you might conceivably want to not be obscure glass. So I'm not convinced that they'll all become not obscure later down the line, and the condition is in perpetuity, isn't it, as far as I understand it. The other observation I would make is that this site is a narrow and long site, just like every other Victorian terrace house in the whole city. And the house I live in has no windows on either side. It's a long, thin plot, probably not a lot wider than this plot. So villages are different than the city. I get that. I think that we need to be clear about what our reasoning is if we're going to be putting a refusal through. And as I say, I'm with Councillor Webb at the moment. I'm just not clear that a strong case has been put forward for a refusal on this. We might not like it, but it's about the legislation.
Thank you. And I've got Councillor Galvin and Councillor Fisher. You seem to stuck your hands up. You could try and keep it brief, I guess, because I would like to get.
All I wanted to say is this: I do take the point that has been made. I recollect. I think we had a site at Heworth that Councillor Webb was violently opposed to, and I can't remember whether it was granted or not. And I think the argument then was overdevelopment, and it was a biggish site. I'm sorry, this is totally inappropriate on this size of plot. It is not. If it was shorter and wider, 30% shorter and 30% wider, then it may well be that it would have a reasonable argument for such a development. But this site is totally inappropriate. And if you want an answer, it's very simple: overdevelopment of the site. End of.
Councillor Fisher.
To come back to what Councillor Webb said, I don't think we should actually be afraid of appeals where we think we have a justifiable reason. And I think overdevelopment of this site is a justifiable reason. And consequently, I would not be concerned about getting costs awarded against us in this site. I think we have sufficient grounds for refusal to actually justify that. I'm sorry to have to push officers into an appeal because it takes time. but I don't think we should accept back planning. And I think this site in a conservation area, we've seen a number of appeals where the planning inspector has agreed with us that the site was overdeveloped and the building appeared cramped in the site. There have been quite a few of those in recent years, so they do take that into account. Plus the fact this is in a conservation area, and I think we should bear that in mind. I'll leave it to the rest of us to make our mind up now. I've said my bit.
Thank you. So yeah, I think it is probably time to put this to a vote. I mean, we may very well come back looking for a different proposal, but we'll see. For my part, I just don't really see what the issue is with this. It looks like quite an innovative use of a constrained site, yes, but sort of clever placement of the rooms to minimise that issue. And it's not necessarily the distance per se, but the issues that creates that's the issue. And I can't see any policy that's been contravened anywhere in this, so I'm happy to support it. And Councillor Crackhill, very quickly, I would like to.
Yes, it was just that we're going to a vote for approval, aren't we? So I just wanted to ask if the committee would be happy to add in a construction management plan.
I'm sure we would be. I think at the moment it's only really Councillor Webb and I that have expressed support for it, but presumably Councillor Webb, if you're happy, I am.
I'd be happy for Chair and Vice Chair to look at something after the meeting that would work, but it's only for one plot, as Gareth said earlier. But yeah, I'm happy for something to go ahead.
Okay. Gareth, then if you could give us a quick summary of where we are. And Jane, if you're still in the background.
Thanks, Chair. So it's been moved that permission be granted. No, that you recommend to the Chief Operating Officer that permission is granted for the erection of the dwelling in line with the recommendation, in accordance with the conditions outlined in the recommendation, and an additional condition that for a construction environment management plan. Can I suggest that is the wording of the construction environment management plan is in consultation with Chair and Vice Chair, would devise something which is proportionate to this site, because obviously you've seen our construction environment plan. The condition runs to more than a page, and it's probably out of proportion with this scheme. But we can come up with something that is reasonable for this site.
Yeah, I'm sure we're happy with that. And sorry, did you mention the updated conditions? Sorry,
I turned off on, back on again. The conditions, there were no updated conditions. The update was from the neighbour, questioned the ability of the applicant to comply with the conditions that were proposed. We're not actually proposing that any of those conditions are changed.
Those are the words that are coming out of my mouth. It was a stupid thing to say. Sorry, Sandra, you just appeared.
Yes, Chair, I'm sorry to interject, but I've just been notified that Councillor Corshaw may have temporarily lost some connection and may possibly not have heard all of the debate or a response that Councillor Galvin gave. Is that correct? In which case, I'm not sure whether Councillor Corshaw has missed anything or anything needs to be repeated for his benefit before the vote.
Thank you, Sandra. I was going to ask when just before we got to that point. I may have broken up when I was speaking, and I certainly missed the next person who spoke. Councillor Galvin, I think, was replying to me. I think I missed about 5 or 10 seconds of the start of his reply to me. So I'm comfortable that I absolutely understand the gist of what he was responding to me. So unless there's another reason why if you think I shouldn't take part in the vote, I'm happy to take your advice on it, but I don't think I missed more than about 10 seconds of speech, and certainly got the gist of what Councillor Galvin was responding.
Chair, that sounds fine to me. Sorry for interrupting. I just thought
No,
I'd better check.
Thank you.
Thank you.
Thank you. Okay, I think we're ready then to move to the vote. Jane, if you're able to conduct it, please.
Okay, so I'll ask you again to vote in alphabetical order. Please state if you are for, against, or if you wish to abstain. Councillor Craghill.
Against.
Councillor Crawshaw.
For.
Councillor Daubney.
Against.
Councillor Fisher.
Against.
Councillor Galvin. Councillor Galvin.
Sorry, I hadn't unmuted myself. Against.
Councillor Melly.
Makes a change.
4.
Councillor Orrell.
For.
Councillor Perrott.
Against.
Councillor Wardby.
Against.
Councillor Webb.
For.
And Councillor Hollier.
For.
Okay, that's not passed.
Okay. That was 5, 4 and 6 against, so
correct.
I'll ask them if there's any alternative proposal. Councillor Galvin. Sorry, you're muted.
I'm getting ready for my tea. I'm hungry. I'm going to move, Chair, that this application is refused on the basis of overdevelopment of the site.
Thank you. Gareth?
I just overdevelopment as a standalone word in a refusal reason is we normally need to flesh it out in terms of saying what is harmed from that overdevelopment. Is it the impact on the character and appearance of the conservation area? Is it neighbouring amenity by reason of X, Y, and Z? That sort of thing.
Neighbouring amenities, Chair, and impact on the conservation area. Will that do, Gareth?
Could I add cramped appearance? I think cramped is the word I would use.
That's a technical term, Tom.
It's been used by inspectors on several occasions when they've been describing an overdevelopment. So cramped, cramped.
Yeah.
I'm happy with cramped as a word that's that we can use in a refusal reason. And so harmful to the character and appearance of the conservation area.
Okay, Councillor Fisher,
okay.
that?
I'm quite happy. I'm prepared to second that. I'm sad because the actual internal structure of the house is brilliant. I just think it's the fact it's just too narrow a site.
Thank you. And Councillor Melly?
I'm really struggling with this application because I can see both sides, and when you're looking at the planning balance, I feel like both sides are almost perfectly balanced. But I was just wondering, in terms of reasons for refusal and the impact on neighbour amenity, what amenity? It doesn't seem to be having much impact on amenity space or light or kind of noise impacts. I'm not sure exactly what sort of amenity is being kind of proposed as being negatively impacted. Somebody please clarify.
I was going to ask the same question because it's normally our policies are couched in terms of impact on sunlight, daylight, impact on like an overbearing impact from large structures. that sort of thing, rather than amenity as a, it does have to be qualified.
Councillor Fisher.
Thank you. I can't see the amenity of the neighbouring dwellings as being a particular issue in this. I don't think the overshadowing of the Methodist Church is particularly a problem. I would just stick to the one thing. It's a cramped development, which is detrimental to the appearance of the conservation area, and leave it at that.
Galvin's nodding. Councillor Daubney.
I would suggest it's overbearing to the residents of the Methodist Church. There'll be a large wall between 1 metre and ½ metre from their fence, and that's very close to where they're going to be sitting on their patio, particularly where the children are enjoying vacational time.
Thank you. I think though that Councillor Galvin and Councillor Fisher have agreed to that one reason.
Well, yeah, okay. I mean, again, I think the same argument could be used for number 21, but fine. I mean,
yeah. I think we've got agreement on that one reason as sort of proposed from reverse by Councillor Fisher. So if you two are happy to stick with that, that's probably the best grounds to move to a vote on. Yeah, okay. So, Gareth, you able to give us a summary where we are?
Yes, so it's been moved that the subcommittee recommend to the Chief Operating Officer that permission is refused because of the overdevelopment of the site. The erection of a house on a very narrow plot would be of cramped appearance and out of character and harmful to the character and appearance of the conservation area.
Okay. So we see nods. So Jane, if you're able then to conduct the vote, please.
Thank you, Chair. So again, I'll take the vote in alphabetical order. So please state if you're for, against, or if you wish to abstain. Councillor Craghill.
For.
Councillor Crawshaw.
Against.
Councillor Daubney.
For.
Councillor Fisher.
For.
Councillor Galvin. Councillor Galvin.
oh, sorry, I was daydreaming.
Councillor Melly.
Against.
Councillor Orrell.
Against.
Councillor Perrott.
For.
Councillor Wardby. For. Councillor Webb.
Against.
And Councillor Hollier. Councillor Hollier.
Against.
Thank you. So that's passed 6-5.
Okay, thank you. So that motion has been passed. Yeah, and that was 6-4 and 5 against. Okay, so thank you very much, everybody, this evening, and in particular as well, thank you to our technical and planning staff in the background. I know we've had a few technical issues along the way, and I'm sure we'll all be glad to be getting back to in-person meetings and hopefully trying to keep some of the benefits we've had from the virtual meetings as well. But we'll see if that's possible. So thank you, everybody.